Contract law forms the backbone of business transactions and personal agreements in Kentucky. Understanding the nuances of Kentucky contract law is crucial for protecting your rights and interests. This video will guide you through the key aspects of contract law in the Bluegrass State, focusing on breach of contract defenses and remedies. In Kentucky, a valid contract requires three essential elements: an offer, acceptance, and consideration. While both written and oral contracts are recognized, certain agreements must be in writing to be enforceable. These include real estate transactions, contracts lasting more than 1 year, and sales of goods over $500. A breach of contract occurs when one party fails to fulfill their contractual obligations. To successfully claim a breach in Kentucky, the plaintiff must prove 4 key points: the existence of a valid contract, the plaintiff's fulfillment of their duties, the defendant's failure to meet their obligations, and damages resulting from the breach. If you find yourself accused of breaching a contract, Kentucky law provides several defenses. These include lack of a written contract when required, misrepresentation, incapacity, undue influence, mutual mistakes, and unconscionability. Additional defenses recognized in Kentucky include fraud, impossibility of performance, frustration of purpose, and failure of consideration. When a breach occurs, Kentucky courts may award various types of damages. Compensatory damages aim to make the non-breaching party whole again. Expectation damages cover what the non-breaching party expected to gain from the contract. Reliance damages compensate for losses incurred while performing contractual duties. Other types include consequential, liquidated, and restitution damages. Punitive damages are rare in contract cases, but may be awarded in instances of fraud or malicious conduct. Kentucky has specific rules governing certain contract disputes. For example, construction contracts may have unique defenses related to unforeseen conditions. The state also sets time limits for filing breach of contract claims, known as statutes of limitations. Written contracts generally have a 10-year limit, while oral contracts have a 5-year limit. Beyond monetary damages, Kentucky courts can provide other remedies for breach of contract. These include specific performance, where the court orders the breaching party to fulfill their obligations, particularly in real estate transactions. Courts may also issue injunctions to prevent ongoing harm or rescind the contract entirely. Many contract disputes in Kentucky are resolved through the state's court system, with complex commercial cases often handled by the Kentucky Business Court docket. Alternative dispute resolution methods like mediation and arbitration are also common. Given the complexities of contract law, seeking legal counsel is advisable when facing a contract dispute in Kentucky. An experienced attorney can help navigate the intricacies of state law, build a strong case, and pursue the most appropriate remedies for your situation. Understanding Kentucky contract law is essential for anyone engaging in business or personal agreements within the state. By familiarizing yourself with the key principles of contract formation, breach, defenses, and remedies, you can better protect your interests and rights in contractual relationships.